In 1966, Reuben Hurricane Carter was a top-ranked middleweight boxer when overnight his climb to fame and success from Paterson, New Jersey, a stint in the Army unsuccessful, and what looked like finally a trip to the high life was disrupted, finding himself accused of being the shooter, the lead shooter, in a gangland-styled execution at the Lafayette Bar and Grill in Paterson, New Jersey. Folk songwriter John Dillon even wrote a popular song about the man they called the Hurricane. And he did gain a brief release finally in 1975 after serving almost a decade in state prison. But it was not until 10 years later, in 1985, after all state appeals had been exhausted, that the only remaining avenue for relief was to file for a writ of habeas corpus in federal court. And for approximately 74% of litigation commenced in federal courts without the assistance of an attorney, this Latin phrase becomes perhaps the only useful Latin phrase they need to know as a hope of finally gaining release from incarceration, because of what it constituted an unlawful detainer. Though what attorneys and even the Supreme Court has described often as an extraordinary writ, because they are rarely granted except under the most extraordinary circumstances in which any other action would be tantamount to a manifest injustice. Hello, my name is Major Mike Webb, and in the year that the Hurricane Carter was beginning what would become 2 decades lost from his life, I was just being born in New Jersey and would become a childhood protege of his criminal defense attorney, Raymond A. Brown. And now, in what attorneys would call a case of first impression, I am beginning to mount a petition for extraordinary relief under a writ of habeas corpus, a Latin phrase that literally translates into "you have the body." And for the next few minutes, we are going to try to explain this legal concept in easy language to understand that had for centuries been considered to be a cornerstone of democracy in a republic. Just as important as, maybe more important than voting, and dating back to even before the Magna Carta in 1215, when some nobles in England got a little fed up with King John in England and said, enough is enough. Now, some may have noticed after a recent YouTube video about suddenly dying, there has been a considerable amount of fact-checking, backlash, and even censorship about anything contrary to the claim by pharmaceutical companies and government public officials regarding what has at least been repeatedly described as the safe and effective vaccines to combat COVID-19, which the president had used to place the nation on what he had described as a war footing against an invisible enemy on the first anniversary of the pandemic declaration by the World Health Organization, on an assurance that his American Rescue Plan would not fail, months before these products had even yet been approved by the FDA. And around the same time, after conferring with the Director for National Intelligence, or DNI, and the intelligence community, he had announced that the U.S. intelligence community has coalesced around 2 likely scenarios, but has not reached a definitive conclusion on this question, stating that while 2 elements in the IC leans toward the former scenario, and 1 leans more toward the latter, each with a low or a moderate confidence, the majority of elements do not believe there is sufficient information to assess one to be more likely than the other. Essentially, they rolled craps, or even snake eyes, and could not come up with an answer. It was a story that gained some traction for a little while during another election year, and that later had faded away after the election. But now in a recent report from the nation's leading business journal, the Wall Street Journal, the story has been revived again, reporting now that there were two competing hypotheses amongst the American general public. An American general public that, according to recent surveys, over 70% are not pleased with the way that the government is going, regardless of party or ideology. And some Americans believe that the novel coronavirus probably escaped from a laboratory in Wuhan, while yet others maintain the virus first jumped to people from caged animals at a Wuhan seafood market. But bear in mind that only 43% of Americans hold a bachelor's degree, and only 6% of those who hold a bachelor's degree majored in biology. Only 2% of those go on to continue through graduate work. But for now, for most Americans, only two possible scenarios are on the table of consideration. But what if there is a third, or even fourth, or even fifth conceivable, if not plausible, alternative scenario to explain this novel coronavirus? Well, in terms of public approval, at least any other possibilities are off the table, which had become a major stumbling block for almost 3 years of litigation that I had commenced almost from the beginning of the public health crisis, just happening by providence or just serendipity to have been in a position where I was in possession of some inside information regarding public health crises, having once served as the most junior commissioned officer to have ever served as the operations officer for all U.S. Army Strategic Counterintelligence in the continental United States, or CONUS, which one would think should be a good resume bullet during what has been described as a once-in-a-lifetime pandemic. But you may have noticed that I am not being interviewed on either CNN or Fox News, or even being invited to the White House or Congress. So, when it comes to being labeled as a crackpot theory, one might get the idea from the lack of attention, at least, that my thoughts have to be pretty beyond even what some might describe as on the fringe. But having served in a capacity to essentially be described as a biological warfare planner, I just happen to have one credential that most don't have. I can be certified to testify as an expert in a state or federal court. And this is where the writ of habeas corpus gets connected to those cases, a half dozen that have gone all the way to the U.S. Supreme Court, and yet have never made any mention in the news, which should raise a reasonable inference of suspicion. And through a little bit of evolutionary pressure, we have now decided to try something new. If you could continue to do the same thing over and over again and expect different results, some say that sounds a little crazy. And so we're going to improvise, adapt, and overcome and see what can be done with this writ of habeas corpus. And let's get a little bit into that and how that applies. Some people, perhaps through experience, personal, or maybe even watching courtroom dramas on television and in the movies, may be familiar with the legal term false arrest. Others may have become familiar with the more technical sounding phrase wrongful detainer, where the basic idea is that a person has been restricted in their liberty for at least suspect reasons. This is very different from property, where you're going to have actions in replevin, or a more modern concept, detenue. Someone took your property for unjust reasons and you want it back. And when the government does that, this comes under what attorneys would call the takings clause. The takings clause of the due process clause, that you cannot take property without due process or just compensation. But those literary aficionados who like to read books may find novels like The Man in the Iron Mask or The Count of Monte Cristo coming to mind because these characters, or protagonists as they say in high school and college literature courses, have been placed under arrest and jailed for apparently unlawful reasons. And it was exactly this situation that had quite a few of the noblemen in 1215 more than a little upset with King John. Imagine here you are, a lord or earl, and suddenly, the king's police are showing up and putting you in jail for no reason. For those who participate in demonstration marches screaming Black Lives Matter, or for those who were concerned about folks who got arrested for participation in the events on January 6th, this is that same general idea of being placed in custody, incarceration, for suspect reasons. So, everyone should have some common emotional experience, even if vicarious, about why these nobles may have been a little upset way back in the 13th century and decided to march on up to the castle, set off an insurrection to call the king to the carpet to say enough is enough, this has to stop. Now, let's delve a little deeper into how this jurisprudential notion of a writ of habeas corpus in extraordinary relief might somehow apply to this potentially additional body of knowledge. And that idea of a body of knowledge was not simply just something that finds coincidental correlation between this innovative usage and understanding of a legal technique application that we are bringing to the courts, but because it happens also to involve bringing a body, a physical body of knowledge in the form of an expert witness to testify on a matter related to disease and vaccines, a topic about which Justice Harlan, speaking for the majority of the Supreme Court in Jacobson v. Massachusetts, which some may recall is the smallpox vaccine case back in 1905, had said the only competent evidence that could be presented to the courts to prove these propositions was the testimony of not laymen like Pastor Hemming Jacobson, who had a lot of interesting ideas and thoughts and feelings about vaccines and the smallpox epidemic, but experts giving their opinions. And you may recall that he lost that case. But he also brought the interesting argument about having had derogated preamble rights, which brought on the immediate reprimand of the Supreme Court in the first paragraph. And back in June 2020, when according to Pew Research Center, some 73% of Democrats and some 66% of Republicans were pretty confident that they understood the evolving science in a pandemic, that even fine scientists still confused. Apparently, the Washington Post had reported that months of discourse about the coronavirus epidemic have transformed the cloth mask into a potent political symbol, touted by Democrats as a key part of communal responsibility, labeled by some GOP leaders as a sign of government overreach, and as a scarlet letter pinned on the wheat. But while these may describe political attitudes about these devices, which are essentially really just kind of provocative feelings, these substitutes for medical-grade personal protective equipment that may or may not save your life in a lethal pandemic, not even one of them, even for those who claim that they had voted for the science, had anything at all to do with the efficacy or even effectiveness of these hydrophilic substitutes for medical grade protection. Also, none had read a report by NIOSH about a decade ago. And if you are not familiar with this phrase hydrophilic, which is often compared to hydrophobic, it might be a good time to practice thinking like a scientist to look it up. Under the evolutionary pressure of a global public health crisis that found some not wanting to play Russian roulette with a virus that isn't stupid. In the jungle, the strong survive and the weak perish. And Darwinian evolution is all about natural selection. Knowledge is power, they say. Battle is won, be fought is fought. And you look like an intelligent person. One popular saying is that only a fool represents himself in court. And while Hurricane Carter had Ray Brown and a host of other attorneys trying to free him for 2 decades, over 74% of the cases brought to federal court without an attorney are men and women who are incarcerated, going it alone without an attorney. And it may not be surprising that most of these do-it-yourself legal defenses fail. Why? At least in part because even if they had performed enough research to learn a new Latin phrase like habeas corpus, they are not on the level of at least a middleweight champion in that boxing ring like Hurricane Carter was in professional boxing. And they are going against professional prosecutors who do this hand-to-hand combat in the courtroom every day and talking to judges, most of whom have gone to law school and practiced law. And in court, even if you have the right facts on your side, you can lose your case by just saying it in the wrong way. Even if you have the right facts on your side, you can lose by just saying it in the wrong way. And there was a member, in fact, of Senator Raphael Warnock's church down in Atlanta who had tried to sue him for what she said was a malicious prosecution. And with his buttocks on the line, even that reverend was not the least bit forgiving, and his attorneys had her case dismissed because she didn't use the correct phrase for her facts. Abusive process. Case dismissed. See the clerk. An ounce of prevention is worth a load of care, they say. And you have a pandemic crisis. Now, if you are bringing a case to court, you have to remember that nobody is exactly happy to be summoned into a courtroom with you, not even defendants or the prosecutor. And they're going to grab some high-paid lawyers in Brooks Brothers suits and Gucci loafers, lawyer up, and try as best as they can to maintain what amounts to something like a right to remain silent in a criminal prosecution, even though you are in a civil case. And if you have ever told an officer that you had no idea exactly how fast you were going when he stopped you, you already know how this works. And if you don't, well, you probably paid a lot of fines. And just like Reverend Warnock, forgiving 7 times 70 in church in a sermon is not going to be that Jesus of second and third chances in court and is going to get his team of attorneys to dismiss your case. Most often in federal court under what is called a 12b6 motion, or you may hear the legalese phrase, demur, for failing to state a legal cause of action. That's going to be what you're going to face in court at the outset. Nobody's just going to say, yes, sure, come on and sue me. And if you don't survive this first round of battle, your case is over unless you try to appeal. And you can try that, but if you fail to do your homework in the first place, fail to study for the exam, as the president says, his football coach used to say, lots of luck in your senior year. But you have something on your side, and that has been built up over years of establishing what is called precedent in stare decisis from prior cases. And as long as your allegations in your complaint have facial plausibility, you should survive that first skirmish against defendants in court, because although you don't have to try your case on the merits, in this test of the pleadings, as they say, your allegations still have to satisfy the threshold of going beyond the speculative to at least that which is plausible, not just conceivable. But imagine being a guy like Galileo going up against the Vatican in the 16th and 17th century, and trying to argue to them and everybody else what he described as science. Perception is reality. The majority rules. He had to look like a crackpot. And you can see very readily why he may have wanted to recant even before he was brought to the Inquisition. and shown the many ways that they had to make him reconsider his notions of science by applying, shall we say, a little evolutionary pressure. Not a good meeting. And currently, the broad perception of reality is pretty much the two scenarios around which the intelligence community had coalesced as far back as the first anniversary of the pandemic. Very stagnant, still the same. And if you think that after the balloons controversy there was going to be any progress on getting into the Wuhan laboratory, if that's where you think this virus came from, as the Wall Street Journal had even suggested, just like Secretary of State Anthony Blinken had in his interview with Axios editor Mike Allen. Let's just say my football coach in high school used to say, "Good luck in senior year." I didn't even play football, but in court, met with a motion to dismiss now in two actions that revolve around answering this very question about the origin and the nature of this virus. One in Alexandria and another down in Chesterfield. We now have to rely upon an expert to bring about what scientists call a revolutionary paradigmatic shift, to be just like a Galileo and later Einstein, introducing a new theory based on a science to explain these once-in-a-lifetime events. And unfortunately, since a motion to dismiss is an attempt by the court to quash a case before it gets that full day in court in a trial, generally under the rules, you cannot bring forward an expert to be certified to testify on the witness stand, just to make that argument that there is another plausible explanation for all of this. And as they say in Jersey, we gotta move the body. And this is another reason why a habeas corpus, you have the body, is even described in most state and federal laws as an extraordinary writ, because it's an application that is not usually done. It's not usually in the rules. And this comes under what is called acts in equity, basically trying to achieve justice. And those go by certain other rules, but it's definitely within the powers of a court in what are called inherent powers. And here at least the Wall Street Journal agrees that more than 3 years after the start of the global pandemic, there is yet to be a comprehensive forensic investigation into its origins. And they agree that with more than 1 million Americans dead from COVID-19 and an estimated 15 million dead worldwide, that's inexcusable. And at least back in September 2021, even Dr. Christian Anderson, the author of the definitive Zoonotic Evolution Report, had conceded that failure to comprehensively investigate the zoonotic origin through collaborative and carefully coordinated studies would leave the world vulnerable to future pandemics arising from the same human activities that have repeatedly put us on a collision course with novel viruses. Having a fugitive and unknown zoonotic source on the lam is not a story for success. And that animal that started this pandemic, according to Dr. Anderson, may strike again at any moment and set off a whole new pandemic, just considering how many mutant variants must have developed in almost 3 years from that source, running around, coming into contact with its infected self and infecting others, and so on and so on and so forth, but for which, for some unknown reason, has yet to have occurred or appeared in the news, which in and of itself raises what attorneys would describe as a reasonable inference of suspicion, like we use in a Terry stop when you are pulled over, because there's something that you're doing that seems to indicate that something a little more is going on. That is probably not good. And we have to determine why that scenario has yet to occur. And by providence of good fortune, like we say in Jersey, we have to move the body. although in Jersey it's under different circumstances. And to do that, by the rules, we have to resort to this unique legal application, an extraordinary writ for habeas corpus, to release a body of knowledge currently being censored, even in the court, from an unlawful detainer, with a stifling effect on free speech, common phrase by attorneys and first-year law students. And you have to wonder why not even the press is talking about that free speech. My name is Major Mike Webb, and this briefing is unclassified, honest. This advertisement was authorized by Mike Webb.